What's up, Eitan? How's it going?
Good, Gabe. How are you doing?
Doing great, doing great. All right. So, in our next part of our series on probate, I've had a couple of people reaching out lately regarding summary administration. That's what this topic is today. So, we're going to discuss summary versus full administration in the probate process. When is one required versus the other, and what's the difference between the two? So if you can pick one first and just tell me a little bit about it.
Yeah, absolutely, Gabe. So just to kind of take a quick step back, the whole probate process is based on getting a court order to distribute assets from an estate. So somebody passes away, even if there's a will, you can't just take the house and say, oh, well, the house was left to me, or take money from the bank account and say, oh, well, the money was left to me, or I'm going to forge the person's signature, or the decedent's signature. You actually have to go through a court process to have the will recognized by the court, and then get a court order allowing the distribution of the assets to the people who are the rightful beneficiaries. So there's two ways of doing it. The first is a formal administration, and the second is a summary administration. So the easiest one is the summary administration, and that can take, let's say, anywhere from like 30 to 45 days. The only way that you can do a summary administration, and like I said, it's the easier one, so it's preferable, is that the assets of the probate have to be less than $75,000. Or the person who's passed away has to have been dead for more than 2 years from the date of filing.
So if someone passed away within 2 to 3 months from let's say from today, and we were going to do this, you can still do a summary administration if the proceeds are less than 75,000?
No, you cannot. You have to do a formal administration. Again, this isn't, I just want to say, preface, this isn't legal advice. We're not attorneys. But from our experience in doing probates, often this has been our experience. So in order to do a summary administration, the assets that are subject to probate have to be less than 75,000, or the decedent has to be dead for more than 2 years from the date of filing.
Okay. So sometimes one of the questions that we get, because obviously when we're not involved in this kind of thing, we have no idea how the whole thing works, is let's say your parent passes away and you've been living in the property for a very long time. And let's say you're an adult. And, I've heard people say, well, this is my house too. My parents lived here. I don't want to have to go through all that. It's my house too. And they're under the impression maybe sometimes they can just write up a deed, maybe go online, search for a deed, and kind of fill that out and take it down to the courthouse and have it recorded. What are some things that
you can't do that, right? That is totally 100% illegal. And the reason is because a deed has to have several things on it in order for it to be legal. The deed has to have the legal description of the property. There's also some language, it's called statutory language, that's in the Florida laws that says what words have to be in a deed to constitute it being a legal deed. So that's why you'll see a lot of them, they look the same or they sound the same. But most importantly, it has to be signed by the person who is giving the property, the grantor rather. So the person who is giving the property to the other person or selling the property, their actual signature has to be on the deed. There has to be 2 witnesses, and there has to be a notary, and the notary can be one of those witnesses.
Okay. So that's clear. Now, as it relates to back to summary and full administration. So if it's been, and again, this is just as a general rule of thumb, but if it has been less than 2 years, you have to do a full administration. Let's talk about that. So if you know that information as you go into the attorney, you might even be able to prepare and have some of the paperwork readily available for the attorney. So otherwise, they're going to say, "Hey, go get this stuff." What's some of the stuff that, in order to do? First of all, is an attorney even required to do a probate? Let's get into that a little bit.
So we can talk about that. Also, I want to touch on the actual differences between a formal and summary, and like why you would want to do one versus the other. But really, you don't need an attorney at all. You can do this yourself. Funny enough, though, we've actually purchased properties before from people who are attorneys. There was one. It was a condo in Century Village up in West Palm that we purchased, and the sole beneficiary was an attorney in Ohio. So here he is. He's an Ohio attorney. You think he's a smart guy, which he is, but he's not an attorney in Florida. He started the probate process in Florida, and it got so complicated for him. He threw up his hands and he said, forget it. And so we caught the property before it went to auction, and that's how we were able to work out something with him. But had we not, he would have just lost the property and lost all the money, even being an attorney. So you don't need to be an attorney to file a probate, but it is highly recommended so that it gets done properly.
Okay, so I know that we've seen circumstances where people say, I don't need an attorney. I'm just going to do it myself. They go online, they search, or their friends tell them, or whatever the situation is, and they go about doing the paperwork themselves. How does it come out that it ends up becoming an issue? How does it become known that, hey, this was done incorrectly and this is not recognized?
Well, I'll tell you that the most common thing that we see, not necessarily with probates, but in working in real estate, are deeds where people will try and do their own estate planning. So let's say their parent is close to passing away. They want to avoid probate. And so they go out to Office Depot and they buy a fill in the blank deed. Okay. So they'll buy one of those. They'll go present it to their parents. They'll get a notary, and then they'll sign as a witness. Okay. They, the relative, or they, the grantee, the person who's getting the property, will sign as a witness. The witnesses can't be related to the person who's giving the property or the person who's receiving the property. So they'll sign it as a witness out of convenience, totally invalidates the deed. Or they won't write the legal description properly, they'll write the address. And in Florida, legal descriptions, and the full legal description as it is on the previous deed, not the abbreviated one from the property appraiser, that's what makes it a legal deed. So when you think about technicalities like this, we've seen it where then the property ends up having to go into probate because somebody didn't consult with an attorney when they tried to do their own estate planning.
And then it ends up costing them more in the long run because the things that were done incorrectly have to be undone.
And even worse, let's say there's 3 kids or 3 adult children, and the parent wants to give the property to the person who lives in the property. So say they have a caregiver, their youngest child, who's 40 years old is the caregiver. They say, in exchange for you taking care of me for the last 5 or 10 years, I want you to have the house. So then they put together a deed. They want to save the $500 from meeting with an attorney. They put together their own deed. They record it. It's done improperly, and so therefore it's invalid. Then the parent passes away. Now it has to go through probate. And if the parent hasn't left a will designating the house to go to that particular child, then the house gets split 3 ways between all 3 children. And the person who's been living there, who was promised the house by the parent who they took care of for so many years, now has to move out or faces eviction because their siblings are now entitled to the other pieces of the property.
Wow. So in summary here, the takeaway is that if it's not done correctly, you could run into some major issues down the road, right? So
whether it's probate or anything real estate or anything really that where you could use an attorney, it's always worth the money to do it upfront so that you don't have to go back and correct it later on, where it can cost more money. It could cost you tens or hundreds of thousands of dollars depending upon the value of the asset. Now,
have you, I know the answer to this already. We've seen issues even where attorneys have inadvertently done things incorrectly as well, which also can come to light.
Well, there's different ways to do estate planning. And so, for instance, if you're giving a property, you can do what's called a life estate, where you give somebody a remainder interest in the property so that you can live there for the rest of your life. But then once you pass away, then the property immediately goes to that person and avoids probate. You can also put the property in a trust and then have the beneficiary of the trust be the person who you want to receive the property when you die. You can do a will, which will then have to go through probate. But there's so many different ways to skin the cat, right? There's so many different ways to do it. There's no right way. And so some attorneys they'll have a certain way that they like to do things. And it may not necessarily be the right way or the most efficient way to do it, but they're used to doing only wills, or they're used to only doing trusts, or they're used to only doing life estates. And so if that may not be the best route for this particular circumstance. Okay,
gotcha. All right, so we got back to the full administration. So if you're going to be prepping to, you decide to go with an attorney, and you're going to be prepping to get the paperwork required. By the way, we have a checklist that's available for people. Feel free to reach out to us. We'll give that to you for free, which will give you an idea of what you need in order to start the process, which will save you a little bit of time and money.
One of the other things I want to say is there's a key difference between a formal administration and a summary administration, right? We didn't go over this yet, but the key difference is the appointment of a personal representative. So there's only going to be a personal representative in a formal administration. And what that does, a personal representative is now the person who's in charge of, on behalf of the estate, for making all sorts of decisions. So they're the ones who the court will appoint to sign the deed to a property when it eventually is sold, whether it's sold to a third party or whether it's given to yourself as a beneficiary. They're the ones who are responsible for signing the paperwork to go to the court, handling other affairs of the estate. When you do a formal administration, you have one single point of contact, aside from the attorney, of course. And so that makes it easier when you're dealing with multiple family members. You have one point of contact on a formal administration who handles everything. Now, of course, the other beneficiaries have to consent and allow for that person to be appointed the personal representative. But once that consent is given, then they can do whatever the court allows them to do. In a summary administration, it's easier to get it done faster and easier, but there's no central point of contact. There's no single person who's handling all the affairs of the estate. So let's say there's multiple beneficiaries involved and you're selling a property. Those beneficiaries will have the property put in their name, in each of their names, and then they'll have to each sign deeds to the ultimate buyer. Whereas with a formal administration, the personal representative will be the sole person signing the deed on behalf of the estate.
And I've got a ton of questions there for what you just said, but let's say, for example, on a full administration where you have a personal representative. By the way, is a personal representative the same as an executor?
Pretty much.
Okay. So you got somebody that's a personal representative, and you mentioned at the end of the summary administration that there will be deeds put in each of the beneficiaries' names, right, for their right in the property or their interest in the property.
Yeah.
A full administration, when you have a personal representative, will the property only be put into their name and not the others at the end?
No. So at the end of the formal administration, the property isn't put into anybody's name. What happens is then there's an order authorizing sale, and so then the personal representative will then be given the right to sign on behalf of the estate to sell the property to the person to the party that's going to be receiving it. So they'll have the right to sign a deed, even though the property was never in their name. So they're signing on behalf of the estate. but they can only do that once they receive court approval, and the court has to approve the who the property is being sold to and for how much.
Okay. So what happens then in the case that you do a full administration? Let's say the family member passed away less than 2 years ago. So you have this full administration, but you have two beneficiaries, say, siblings.
Mm-hmm.
One of them ends up being the personal representative. What if they want to keep it as a family property and maybe one of them wants to live in it? How would that work then once the probate's complete?
So once the probate's complete, in the what they call the petition for administration, you say what it is that you want to do with the assets. And so the beneficiaries would say, okay, well, either per the will or based upon our agreement as the beneficiaries, we would like to keep the property. And so then the personal representative at the conclusion of the probate would then sign a deed on behalf of the estate to 50% to themselves and then 50% to their sibling.
Ah, okay, that makes sense. Now, sometimes family members don't get along, right? Let's say you have a situation where you have a full administration has to be completed. How is it decided as to which one? Let's say in this case there are the two beneficiaries or multiple beneficiaries. How is it decided as to which one would become the personal representative?
So if there's a will, if the decedent has left a will, then they will it will say it'll say in the will who the decedent wanted to be their personal representative. But really, it's decided between the beneficiaries of the estate. So all the heirs have to basically come together, and one person has to say, "All right, I'll handle it. I'll do it." And
what if they're not talking?
Well, if they're not talking, then one person can petition on their own, and they can say that hey, I'm coming here before the court as one of the heirs or one of the beneficiaries of the estate, and this is what I'd like to do, and it's up to all of the other heirs to contest it.
Okay. And in that contesting process, I know we're running just a little over here, but would you know about it? Would you know if you're a sibling and you're a beneficiary? Are you going to know that the other one has taken that action?
Yes, you should know. And the reason is because one of the reasons why they call it a formal administration is because you have to formally notice all parties involved. So not only are you formally noticing all of the beneficiaries, you're also formally noticing any creditors if it's been less than 2 years. So one of the reasons why they have that 2-year threshold is because they want to give creditors of the estate an opportunity to make a claim on the assets that are in the estate. So if let's say there were medical bills that were owed or some other type of debt that was owed, that there's a chance for anybody who needs to make a claim, to know about it. So the same thing with the beneficiaries. You have to formally notice. You have to send them. It's like serving somebody with a lawsuit. You have to serve them with notice, and then they have to acknowledge if they agree with the appointment of the personal representative. They have to, or they have to say, "Hey, I don't agree, but I'm going to object." And there's a certain period of time within which they can object to that. But if not, then they've kind of waived their right.
Okay, great. Obviously, this is there's multiple rabbit holes that we could go down here. We have a lot of information to cover, and we're going to continue to build upon it as the series goes on. Again, I would like to mention that we have a checklist that we'd be happy to give to you. If you would, if you would like it, you can just reach out via the information associated with this video in the description section. Or you have any other questions regarding probate from our experience, we'd be more than happy to share that information with you. Even if you're keeping the property or whatever the situation is. So All right. Thanks a lot, Eitan. We'll pick this up next time and have a great day. All right.
Thanks, everybody.